Support comes from St. Louis Public Library Foundation, helping the library serve children and their families with programs and services needed to become lifelong readers. More information about the foundation is at slpl.org.
This is St. Louis on the Air from St. Louis Public Radio. I'm Sarah Fensky. We turn to lawyers to help us find justice, to make us whole after suffering. But what happens after a natural disaster? Can lawyers possibly help in a situation like that? Today is our Legal Roundtable, and the three top lawyers on our panel will help us grapple with that question and much more. We'll talk about a grieving widower's lawsuit against MoDOT after his wife was killed in a devastating car crash, compounded by piles of snow that he says they cleared improperly. We'll talk about the Missouri Supreme Court's recent ruling that again makes abortion more or less illegal in the state. We'll also talk about a local asphalt company's $109 million victory in court, all over defective parking lots. And to dig into these issues, we have three very smart lawyers joining us today. Nicole Gorofsky is a former prosecutor in both state and federal court. She now practices at Jenkins and Kling PC. Nicole, welcome back.
Thanks for having me.
And we're also joined today by Brenda Talent. She's a longtime attorney, previously a partner at the firm now known as Bryan Cave Leighton Paisner. Today, she's the CEO of the Show Me Institute, which advocates for small government and market solutions for public policy in Missouri. Brenda, welcome back.
Thank you for having me.
And today, we're also joined by Jim Wersch. He's a former public defender. He's now in private practice as a founding partner at the law firm Casale Wersch, where he specializes in civil rights litigation. Jim, welcome back.
Thanks for having me, Sarah.
So, the big thing that happened in St. Louis this past month has been what we like to call an act of God. This was a massive tornado that ripped a path through the city a mile wide. And so, since we're here to talk about the law, let's consider a legal question. Does a natural disaster like that present opportunities for lawyers to hold people accountable? So I want to start with one of the biggest post-tornado revelations, and that's that the city failed to sound the alarms that warn people who are outdoors to take shelter. Could there be a successful cause of action from someone whose loved one died in the tornado? Brenda, this feels like something where we want to believe somebody could be held accountable, should be held accountable. Is there a way to pursue a lawsuit over something like a siren when the tornado is actually the thing that does the killing?
Well, I mean, obviously what you have to overcome is the whole theory of sovereign immunity, that when you're dealing with a government entity, that they can foreclose lawsuits against them. And there are some limited exceptions to that. And the question is, can you carve out one of those exceptions to say that they assumed a duty, they were negligent in that duty, and because of their failure, whatever the dangerous condition was, that the injury resulted directly from that. It's a pretty big hurdle to overcome. I think there are some other issues you can look here. You know, if we're getting federal relief, could any of that federal relief be conditioned on the municipality waiving any sovereign immunity? I don't know if they've ever, the federal government puts those kind of strings on it. I would say the key here is if you're going to sue, there's always an opportunity. Can you avoid a motion to dismiss? And if you can get past that, then I think that there's going to be a lot of incentives for municipalities to settle if they can't get that motion to dismiss.
That's a very important hurdle. Nobody would settle unless the case makes it past that sovereign immunity hurdle. Jim, you spend a lot of time trying to get past sovereign immunity. Do you think there's a way that it could be done successfully on this kind of case?
On the siren issue, I think it would be very difficult. I think there are other things you could potentially look at. I know there was a gentleman who I believe passed away in Carondelet Park when a tree fell on him.
Tree fell, I think, on his car,
yeah.
right? Or his food truck, maybe.
You could look at, there was recently a lawsuit against the city over its failure to maintain trees, and the city was hit with a verdict on that for over $1 million. And there's definitely a waiver of sovereign immunity on that issue for creating a dangerous condition that they knew about. Now, you're going to have an intervening tornado, but, if this happened to be a tree that they knew was problematic or something like that, that could be an avenue for relief.
Okay, so a dangerous condition that they knew about. We know now there was an audit about a year ago where they looked at the Emergency Management Agency, and a lot of things were pointed out that these are problems with this. It doesn't really feel like anybody ran with that and fixed it. Could the dangerous condition be we have lousy policies and our siren system isn't we haven't done a good job of taking care of who should be handling it?
In an ideal world, yes, but the statute says dangerous condition on property.
So it has to be a physical dangerous condition.
Yeah.
And the dangerous condition would not count as where the siren is sitting unless the siren, well, we now know one of these sirens potentially didn't even sound. Yeah. Could that be a way in?
And I was going to say on top of it, it has to be not only a dangerous condition of property, but that dangerous condition of property has to be what led to the harm. So it can't be, the siren was, not working right and we're going to call that dangerous. But that's not the issue. It has to be the dangerous condition of property led to the harm.
Okay, so you think the siren case, this would probably not be a great case, as tragic as it was.
Yeah.
What do you think about this tree theory? A tree that was maybe too old, not being well pruned. This falls on a car.
That's a lot more interesting, and I think lawyers could maybe make something out of that, because if they knew about it and didn't do anything about it, or if even they did something to it that made it that way, who knows what was going on with the trees on the property, that could be considered a dangerous condition of property, and that could be a more interesting case.
So we know that there were trees all over the city that fell on cars all over the city. I think this one in Carondelet caught your eye because somebody perished in this. That makes it...
That, and it wasn't... My understanding is Carondelet Park wasn't in the tornado path. It was just part of the storm.
So that maybe makes it a better case.
Yeah.
Say that a tornado fells a tree on a car, but nobody dies. Is that going to be the kind of case that a lawyer is going to take up? Hey, I'm going to make you whole because your car was destroyed by this tree.
I mean, that's not the difference in the law. That might be the difference in what the damages are and whether a lawyer is willing to take it on a contingency fee type basis. But that's not the difference in the law, no.
Okay.
Well, I would just add that, the public entity has to have constructive notice of the fact that there is this dangerous condition in a sufficient amount of time that they could have taken action. So it's the kind of thing if they just found out, the morning of, they don't have reasonable time to take action. So that there's also that element to waiving sovereign immunity.
So if there was, say, a report that was like, there's all these dangerous trees in Carondelet Park, and that report came out a year ago, that would be what a lawyer would want.
Right.
So a lot of lawyers have stepped up in the aftermath of this tornado. I want to give credit where it's due. A number of them volunteered to offer free advice to people who were affected by the tornado. My colleague at St. Louis Magazine, Ryan Kroll, he quoted one of them. This is Matt Devote, who's also an alderman in the city. He said the questions fell into three camps. These are tenants dealing with landlords and vice versa, property owners dealing with contractors, and everyone who has insurance dealing with their insurance company. Matt Devote had a great quote. He said, insurers are difficult to deal with. I put 5 kids through college dealing with insurance companies. Right. I hate to think they wouldn't just pay up, but is this going to be a situation that's going to keep lawyers around town pretty busy just trying to get people what their policies say they should have?
For sure. I mean, every time there's a natural disaster like this, that's exactly what happens. There's litigation on non-payments, underpayments, not coming out to inspect, all kinds of issues that are absolutely going to be potentially litigated here.
And are these issues where lawyers can get a decent payment? Somebody who's struggling they're trying to get their insurance to pay. They might think, okay, I can't afford a lawyer to fight this for me. Is there a way that this does all pencil out?
Sure. It depends on the amount of the non-payment or underpayment, right? Again, if we're talking about an attorney who's taking these on a contingency fee basis, it's going to be, what's a third of, what happened here.
Well, and there are a number of lawyers stepping up, I think, just to provide pro bono services because they recognize the disaster and the need to help these people navigate the system.
Yeah, and absolutely. And that is what Matt Devote was out there doing. As much as he had this great quote about fighting these insurance companies, I think a lot of people are trying to lend their support. When we talk about these contingency fee arrangements, this is basically the lawyers taking it on and saying, you don't have to pay me, but I'm going to get 1/3 of the settlement. That's the pretty standard arrangement there.
The percentage differs.
Jim doesn't want to be on the record with that 1/3. Interesting.
Negotiate.
Yeah, the different lawyers do different things. But well, and the other thing to look at is, a lot of these will be insurance denials. And so if the insurance company denies in bad faith, that's its own independent cause of action. And that could be a place where attorneys on a relatively small case might be more amenable to taking that on because the denial itself caused harm.
And so that then becomes something
The damages could be higher.
Higher damages, that means it's worth a lawyer's time to take that case.
All cases are worth it.
Of course. You guys are fighting for justice.
Well, we all should be prepared for premiums to go up or maybe some insurance companies to pull out of Missouri.
Wow.
One of the things I just wanted to mention, which is a question that you didn't ask, but the Missouri Association of Trial Lawyers has a pamphlet or a booklet on this. Typical questions that people might have, frequently asked questions about what to do after a disaster, which I looked at in preparing for today, and it actually has, if my landlord does this, what can I do? Or if my insurer does X, what can I do? It's actually a great resource for the listeners if people want to go look at that.
So that's the Missouri Association of Trial Attorneys. And we should mention they were the ones who were out there providing these pro bono services. Yeah. They sometimes do get a bad rap in certain quarters, like the people that they sue. But it seems like they've done a great job of stepping up here. Anything else on the tornado front that strikes you all as you think about sort of these legal issues, or should we move on to our next case here?
The only thing I would add is it's a reminder to all of us, if you're a homeowner, you should go through all of your rooms, take photos of everything you own, keep an inventory of that, because that's one of the issues you will argue with over insurers is, what did I actually lose?
Wow, that's some good practical advice. Get ready for the next disaster that could strike. Can't believe I'm even saying that. So here's another lawsuit that involves weather and an allegedly flawed man-made response to it. The widower of Colleen Lishwe, who is sort of a well-known water polo coach at McKendree University, he filed a lawsuit after she was killed on a snowy day in January. She was driving on I-44 in the city at the Vandeventer overpass. She had to pull over to the side of the highway. There may have been some sort of problem with her car. There were high piles of snow there, and according to this lawsuit filed by her widower, that apparently contributed to a situation where a semi then struck her Prius and sent it tumbling off the highway to the street below. She was killed. Just an absolutely terrible case. Her former husband is now suing MoDOT. We've talked about how there's probably not a good case over the tornado siren's failure to sound. Nicole, could there be a good case over piles of snow, which again, it feels kind of like this is an act of God that sends snow down onto our highways? What makes this the same? What makes it different?
Yeah, I think this is interesting. If you want to look at sovereign immunity exceptions of dangerous condition of property, it kind of goes on a spectrum. What's a good case? What's not a good case? So the siren is not a dangerous condition of property. We know that's probably not a case we want to take, but the tree was kind of in that gray area where the litigation happens. Now I think is an even little better case is MoDOT creating a pile of snow so the act of God was first, then came in MoDOT that created this pile of snow that then caused a problem. Now you've got they created the dangerous condition of property and it resulted in a harm to the person. This is the better case on the spectrum, in my opinion.
Would MoDOT have been better off in terms of their liability if they had just left the snow on the roads, not tried to clear it to help the rest of us, and not made these dangerous piles?
I mean, that's an awfully cynical opinion. The way I would prefer to say it is they would have been better off had they properly cleared the snow and not created the massive snow pile on the side of the road that led to an
bridge.
Issue. Right.
Yeah, bad placement.
But isn't that actually, that's the question, right? Whether they were negligent in how they cleared the snow. Was creating that pile a negligent action, given the volume of snow and what they were trying to allow the traffic to flow? The other question I have is, what about that semi-truck?
Oh, it's been sued too.
Yeah. Yeah, the semi-truck driver, somebody quoted from one of the accident reports. He said, I bent down to pick up a soda, I looked up, and the car was there. And I'm thinking, oh boy, if I were that guy's lawyer, I would have told him not to talk to the patrolman that seems like if I'm the lawyer on this case, I'm going to blare that in front of the jury.
It's not great for the truck driver.
Yeah. Can MoDOT point to the truck driver and say, hey, we had this pile of snow, but this was something that we had to do. The snow was falling. If the truck driver had not just driven better, this wouldn't be a problem, so we're off the hook.
One of the jobs of a jury is to apportion fault. And so certainly they're going to argue that, the main cause of it is the truck driver, but the jury will be charged with saying, well, maybe it's 90% his fault, but it's also your fault, and award damages against both defendants.
I want to mention also the woman who was killed in this terrible accident, Colleen Lishway is how I should have said her name earlier. This was someone who was killed in the prime of her life. She had a 3-year-old child. Does that have any impact legally on how this case could play out, Nicole?
Again, doesn't have an impact under the law, but under the damages, right? Under the damages section, when you're proving, what, this sounds terrible, but you're in a wrongful death, you're kind of proving what that person's life was worth. And the fact that she was a young mom is certainly, going to have an economic impact on the family. And it's also obviously going to tug at the jury's heartstrings.
We're talking today to our Legal Roundtable. That is Nicole Gorofsky. We're also talking to Brenda Talent and Jim Wersch. We need to take a quick break. When we come back, we'll talk about the fact that abortion providers are back under a de facto ban in Missouri. Which judges are to blame for that situation? This is St. Louis on the Air on St. Louis Public Radio.
The Gateway brings you the day's news each weekday from around the St. Louis region and the state capitals in Jefferson City.
Our schools are accredited. We don't need this bill.
And Springfield.
How many more years must pass before lawmakers see time is of the essence?
I'm Abby Larico. Join me each weekday for The Gateway on the STLPR app or wherever you get podcasts.
Welcome back. I'm Sarah Fensky, and I'm here today because this is our Legal Roundtable. Once a month, we convene some of the greatest legal minds in St. Louis to discuss the most important issues of the day involving the judicial system. It's always a great conversation, and we're joined today by 3 really great attorneys helping us make sense of the law and how it interacts with our day-to-day lives. Today, that includes Jim Wersch, a former public defender, now a founding partner at the firm Kazali Wersch. He specializes in civil rights litigation. Also joined by Brenda Talent, a longtime attorney, previously partner at what is now Bryan Cave Leighton Paisner. She is the CEO of the Show Me Institute. They advocate for small government and market solutions for policy in Missouri. And last but never least, joined by Nicole Gorofsky, a former prosecutor in both state and federal court, and she practices at Jenkins and Kling PC. So the Missouri Supreme Court got everyone's attention earlier this week. The state's highest court issued an order that basically reinstituted a de facto abortion ban across Missouri. And that is even though voters voted last fall to say that they want abortion rights enshrined in the Missouri Constitution. So it seems, how did we get here? Well, the court was responding to a legal challenge to an injunction issued by a judge in Jackson County. That is Jerry Jung. They said that Judge Jung had used the wrong standard in issuing the injunction that allowed abortion to resume in the state of Missouri. Nicole, break this down for us. What happened here?
Okay, let's give maybe a brief history lesson. So, of course, as you just mentioned, Amendment 3 passed last November, which was an initiative on the ballot that legalized abortion, and not just legalized abortion in Missouri, but enshrined it in our Missouri state constitution. We had these trigger laws that had been barring abortion when the Dobbs decision came out prior to that.
So that basically struck down Roe versus Wade.
Correct. And so basically those laws and some other legislation that was happening were putting restrictions on abortion. The ACLU and Planned Parenthood moved to challenge all of those laws because now we have Amendment 3 that went into the Constitution. So that challenge was happening in Jackson County and challenging to all these various laws that restrict abortion care. And there was so what happened is, sorry, this does get me tongue-tied because it is a lot. So basically what happened is they sued for a preliminary injunction because what they wanted was this to go into effect immediately, to say that these statutes were not valid, because abortion care has now been enshrined in the Constitution. I think I've said that several times now. So basically, the judge issued the preliminary injunction and applied a standard that then the Supreme Court said on a writ was not the appropriate standard. So the standard is that they have to say they have a fair chance of prevailing. The judge said that was the standard, fair chance of prevailing. Then the Supreme Court came in and said, well, no, there's this Eighth Circuit precedent that says you have to have more than a fair chance of prevailing. You have to have a really good chance of prevailing, more likely chance. There? There's not a whole lot of difference. And again, these are arguments that keep lawyers in business. But because of that, the Missouri Supreme Court sent it back to the Jackson County judge in order to apply the proper standard to the preliminary injunction.
And is the proper standard as simple as saying, okay, I've got this whole long order here. I'm just going to slide in a couple different sentences saying, yep, it has a pretty good chance of prevailing.
Likely to prevail. So greater than 50% chance. And this is a standard that the Eighth Circuit set when you're talking about challenging an enacted state statute. So it's not the typical standard you would see just for general, temporary restraining orders. It's when you're actually going after a statute that's been enacted that the Eighth Circuit said there's this higher standard. And so when she issued her opinion, and minds can differ on it, that she actually used some language that said it doesn't have to be 50%, and she combined the likelihood of succeeding with the harm and sort of lumped those together. But you're right, it can go back, and she just needs to rewrite her opinion if she believes there's a likely chance to prevail, and look at each of the elements separately and make her findings.
Do you think the Supreme Court was correct? Like, this is the standard she should have used, and this should have been obvious to anybody paying attention? They didn't say that. I'm putting words in their mouth.
I think that, and I didn't look at the dates of her orders, but they were like in 2024, so the Eighth Circuit decisions came down much earlier than that. I don't know if the Missouri Supreme Court had spoken on it. She did cite a Missouri Supreme Court decision, Gabbert, and the Supreme Court specifically said that the Eighth Circuit had rejected the data phase standard, which had been implemented in Gabbert. So that sort of, to me, signals maybe a little bit more of a Westlaw search. I don't know.
Okay.
Which I did.
So she cited something that the court had said, we don't want you to use the standard.
Yeah, she used the Missouri standard that was previously enunciated. The Eighth Circuit, which is the federal court that is overseeing Missouri and other states, they in federal law enunciated a slightly different standard. Missouri courts have not adopted that formally until Tuesday,
just now.
Until Tuesday. So and the interesting thing to me is the Supreme Court kept focusing on whether they were likely to succeed on the merits as the thing she needed to find. And she did find that 7 different times using that phrase. So even if, she did not enunciate the exact language the court wanted her to do, I think, as you said, it will be pretty easy to fix this, given that she has already made the finding that they were looking for.
Do you think the court was sort of going too far here? Or do you think this was fair for them to say, hey, yeah, just give us this different standard. We're giving you another bite at this apple?
This is what judges do. And they send it back, and she'll have a time to ability to reconsider it, and then they'll look at it again.
So that was Tuesday. This is now Thursday. When I hear, hey, Sarah, you need to make an edit on these couple sentences, I'm going to get that done in an hour, and I'm going to then hit publish, because that's what journalists do. What about lawyers, Nicole?
I do think we're being a little bit cynical when we say it's just a matter of changing a couple words. I think at least in theory, what the Missouri Supreme Court was articulating was that they wanted the judge to take a deeper look at the merits of the case and the likelihood of success on the merits, which I think will require more than just a judge's action. I think there may actually have to be some evidence put on, but it still should not take a seriously long time. But it's a little bit more than I think the judge just amending her opinion.
Yeah, I do think, and I know that she used language, James, that you pointed out that would meet the standard. But I do think when I read the first order, which dealt with a number of the statutes, right up front, she said, you don't have to meet 50%. And to me, that sort of stuck in my mind, irrespective of what she said subsequently. And I also think, Nicole, you're correct, because you have to look at, there's a balancing of harm, too. And there's some language that she uses in that regard that I think might also be questionable as a standard apply. I think she needs to dig a little deeper to make the factual findings to say, no, this balance actually goes with the moving party.
And I assume we're also going to have a briefing on it and maybe a hearing, so it's not something you can just fix overnight.
So in the meantime, while we have this briefing, while there's a hearing, is it possible that people will not be allowed to provide abortions in Missouri?
Yep.
So this is on hold for probably a little while.
It is.
I understand we're not talking about a year here, but it sounds like we might be talking about weeks, if not months.
Yes, and it's my understanding that Planned Parenthood has canceled appointments in the near future.
So if I were somebody who was trying to get this sort of care, I think I would be livid. I would say, why didn't the judge just use the harder, higher standard in the first place just to keep this thing moving? Is that a fair criticism?
I don't think so. I think it's pretty hard to predict that the Missouri Supreme Court is going to go out and adopt an Eighth Circuit precedent that it had never adopted before. So I don't really blame the judge. But this is exactly within the Missouri Supreme Court's prerogative to do that and instruct the lower court on what she should do. So I don't know that there's necessarily fault to be apportioned here, but it has happened.
It's interesting to me, we voted last fall for this thing, and now not only have we had this sort of protracted legal back and forth, but now apparently the legislature has put this whole thing back on the ballot. It kind of makes you question, what is even the point of voting on these things? It seems to always come down to lawyers. Lawyers are going to lawyer. Jim?
And politics.
And politics. Yeah, I guess that's my whole complaint here.
And that is a totally different issue, that the legislature is going to try to put another constitutional amendment to then ban abortion with, in my opinion, some sneaky language to not actually say that that's what they're going to do. And that's a whole different ball of wax.
But when you talk about initiative petitions, one could criticize that everybody involved in that process and putting sneaky language in to get things across. And, when you circumvent the legislative process, you don't have all of that give and take, if you will. I think that's one of the things we've seen, a lot of arguments about an initiative process, but that's what it allows.
It's
you
kind of
can
advocates.
keep coming back, and there's no limitation on how often you can come back, because private parties can turn right around and come back with another petition.
Yeah, when I was reading about how the legislature was going to go back and sort of put this question before us again, I thought, we're going to be talking about this on the Legal Roundtable. There's going to be a whole fight. This will happen in court, whether or not this language is the language that makes the ballot. And once again, we're talking about politics, but it seems to always come down to who can afford the best lawyer. It's an interesting paradigm we have in this country.
Or the best marketing campaign.
There you go.
This will certainly give us fodder for multiple shows to come.
People can either look forward to that or dread the fact it's coming. Right? So speaking of politics, before the tornado, one of the highest profile questions for St. Louis Mayor Kara Spencer involves state control of the St. Louis Police Department. On Mayor Tashara Jones' last day in office, the city filed a lawsuit challenging the state bill that took control of the department. And Kara Spencer said she was not consulted in that litigation. Now, that suit had some pretty big deficiencies, as we discussed on this Legal Roundtable last month. But it ended up being dismissed in a way where it could be refiled. And so this month, that's what Aldermanic President Megan Green did. And she did it without Kara Spencer, who is now the mayor. Kara Spencer has suggested that her colleague, Megan Green, jump the gun by going it alone. And I guess I'm wondering, Jim, if you have any thoughts on this. Does the fact that Megan Green filed this lawsuit, does this preclude Kara Spencer from later filing a lawsuit of her own? Would these two sort of dueling pieces of litigation have any impact on each other? Or now that Megan Green, president of the Board of Aldermen, has filed, is this kind of the official legal challenge and the now mayor is somewhat left in the dust?
Well, first of all, I want to note that I do represent Ms. Green in a separate matter unrelated to this. But no, I don't think it precludes the city from coming in later on. I think you can have a subsequent challenge. There are mechanisms to consolidate the cases, put it in front of the same judge. That's so that you're not going to have a risk of inconsistent rulings, because that's what you're really concerned about. I think this is a somewhat urgent issue because the dates of when the takeover is happening is going on.
It's happening in just like a month at this point.
And so, it is something that I think, if you're going to do it, you need to act with some urgency. The jumping the gun, reasonable minds can differ, but I don't think it precludes the city from joining later on.
Do you think, though, does it have any impact depending upon how far this particular lawsuit proceeds? I was just thinking back to my law school days. Okay, not res judicata, not maybe estoppel on legal questions. How about issue preclusion? Depending upon how far this lawsuit gets, couldn't there be some particularly questions of law that are decided that would say, if you don't have the best attorney, they're not making the best argument, that she could actually end up hurting the city's chances if the city wanted to get involved. And what I hear Jim saying is they got to jump in right away. But if they don't and some decisions are made, aren't there some issues there that really...
Potentially. The court could rule on some issues, and that could be problematic. The city would also have the opportunity to intervene in this lawsuit. They could move to intervene. That they might not be allowed to or not, but they could move to do that.
What I worry about a little bit are the optics of it. This is not a legal issue at all, but certainly the optics of what happened with the judge saying that petition was written in haste and was poorly written and all of that. I think that hurts the overall concept, and judges are humans too, and they pay attention to what's happening, in the world. And so I think Kara Spencer's quote about, I think we need to really think this out and go into it, appropriately. I think that's well taken. I do think a unified front probably in terms of optics would be better.
And in terms of this question of consolidation, Jim was saying, they could try to get this in front of the same judge. Is it the judge that decides whether these things get consolidated?
Yeah, of course, there's precedent telling you when it's appropriate to consolidate cases. But ultimately a judge would make that decision.
And then at that point, say we have a consolidated case moving forward, say the mayor and the aldermanic president have sort of a difference on how they'd want to pursue this strategically. They could both be at the table sort of arguing different things. Theoretically?
So that's something that would have to be considered really before the cases were consolidated. Does it really involve, one of the things you look at is, does it involve the same parties? Then you also look at whether it involves the same issues. And those factors should really all come into play and be considered before it would be consolidated.
Well, we definitely know they involve the same parties. It feels like they involve the same issues, but maybe we'd have different ways of looking at those same issues. And that's where, this gets interesting to me. We also see, so many different lawsuits against Roundup, or we see so many different lawsuits against this or that. I've never quite understood, how does one end up being the one that prevails when you might have different things popping up in different venues? Feels like maybe that's what people go to law school to learn. So one last thing I wanted to mention here. As the state is gearing up to take control, there's what feels to me like an unfortunate fact for city residents. And I want to ask you about this, Jim, because I know that you have successfully sued the police department. Your firm does like to do that. This new law ushering in state control limits the amount the state is allowed to pay for liability claims at $2 million per fiscal year. That's between Kansas City and St. Louis, the two departments that seem under state control, that are going to be under state control. That feels absurdly low to me, is it?
Well, it certainly will not cover the verdicts and settlements that'll be coming. And ultimately it's just part of as a city resident, I just feel it's patently unfair for the legislature to be imposing this upon us and then saying, but you foot the bill. It's just wild to me. So that's just part of the whole problem with the entire structure of this bill.
Yeah, and I don't know. I guess previously it was capped at $1 million per fiscal year, and so this does increase it. And yet, Brenda Talent, with all the lawsuits that come out of St. Louis and target this police department, this feels like maybe a fraction of what would be needed.
It may well be, but the state can do that. They can say, this is all we're going to pay. This is all we're going to kick in.
I think it's particularly fascinating if it's something that the state does. So if it's something that happens under the state control, that the state maybe trained an officer improperly or something that arises out of that, I think that's when it really becomes an issue. Why should St. Louis foot the bill for that?
You can see why city residents are a little angry about some of this.
Mm-hmm. Although you could also argue, since the city, and I guess it would depend upon the charter, is a political subdivision of the state. I mean, they exist basically because the state says you can exist, that the state can go, well, that's your responsibility. We're delegating that to you, too.
So under state law, this is all totally legal.
Well, we do have something that is supposed to preclude unfunded mandates, but
We'll find out if this does.
right.
We're talking today to our Legal Roundtable. That is Nicole Gorofsky. We're also joined by Brenda Talent and Jim Wersch. When we come back, we'll talk about a $109 million legal verdict in St. Louis County. Are these verdicts getting bigger and bigger? And is anybody ever going to cash in to that amount? This is St. Louis on the Air on St. Louis Public Radio.
If you have a smart speaker, you have access to the entire world of NPR and St. Louis Public Radio. All the latest news and all the captivating stories. Activate our voices with yours by telling your smart speaker to play St. Louis Public Radio.
Welcome back. I'm Sarah Fensky. I'm here today with our Legal Roundtable, which always convenes in the last week of the month. This is a sign it's almost June that these three brilliant attorneys are here with us today. And that includes Nicole Gorofsky, former prosecutor, now at Jenkins & Kling, PC, as well as Jim Wersch, who's a founding partner at the law firm Casale Wersch. He specializes in civil rights litigation, and also joined by Brenda Talent, who is a longtime attorney and CEO of the Show Me Institute. They advocate for small government and market solutions for public policy in Missouri. So here's an eye-catching little thing that happened in the last month. A St. Louis County jury returned an absolutely enormous verdict, and this was in favor of an asphalt company. Gleason Asphalt alleged that one of its suppliers misrepresented the quality and gradation of its base rock, and that led to failures at 2 surface parking lots. Now, if I heard that little capsule description, I'd be like, yeah, probably not even going to put this one in the magazine this month. This doesn't seem like that big a deal. Well, the jury disagreed on this one. So this asphalt company alleged that it had suffered damages that totaled $942,000. And the jury awarded not just that, so just shy of $1 million for the actual damages, but then it brought in some compensatory damages. And these totaled $108 million in punitive damages. This feels like the kind of sum that we see if a baby has been badly injured, or if someone has lost their life in some sort of catastrophic way, or if someone's going to be dealing with decades of pain and suffering. We're talking about base rock and failed parking lots. Brenda, what's your take on this one?
I think the evidence showing that the contractor engaged in misrepresentation was probably pretty compelling, and people thought this is just a bad actor, and we're going to punish him.
We want to punish this parking lot cheat.
It sounded like there were emails, other kinds of correspondence that was knowing. It was, you could argue it was malicious, whatever, but it was enough that they went for it. I didn't, pull up what the closing arguments were. Maybe the lawyers were particularly, good at making the case for them, but I don't expect to see this punitive damage award stand. The Supreme Court has talked about excessive punitives, and I guess you were saying 9 times what. That's
constitutionally, and I think the
state Missouri is five times punitive damage is the cap, or I'm sorry, 5 times the actual economic damages.
So we have $1 million in actual damages here. The Supreme Court would say you can't go above what?
$5 million.
$5 million. I mean, that's a staggering difference here.
It could be 9, though, because I thought that don't we still have that case on the books? Has it been overruled where the Supreme Court said that if there is a jury trial, you can't place the caps on punitives?
So there are several exceptions to the caps. I don't know that I've gone into all of them, but I know that there are several exceptions to the caps. I think, $109 million is not going to stand.
No.
And just to give like a basic lesson, in order to get punitive damages at all, you have to be able to show that there was willful and wanton behavior. First, you have to show it to the judge to even get it in front of the jury. And then in front of the jury, you have to show that the behavior was willful and wanton. So it does make you think there must have been some fascinating evidence in this case.
Right. The purpose of punitive damages, as Brenda alluded to, is to punish. And so the jury must have really wanted to punish them.
Yeah, I mean, this doesn't sound like the sexiest case, but now I believe like Gleason Asphalt was terribly harmed and this jury was just frothing to bring justice. I wonder about Simon Law Firm, which is the law firm that handled this case. They have had some massive verdicts lately. They are on such a hot streak. And, it seems like they're very excited about how a lot of this is playing out. Does it help them at all that they get this $109 million verdict built on $108 million in punitive damages if that doesn't end up holding up? Does that help them in some way that I'm not
seeing?
The
marketing alone.
Yep.
Okay.
It's the marketing.
I mean, the Simon Law Firm is considered one of the, if not the top plaintiffs firm in town. No offense to everyone else, including myself. But when you see these numbers and they're attached to them, and they can put them on their website, and I mean, it's great marketing, and no one ever asks what it all ended up being. They just know what the verdict is, and that's a nice shiny object to advertise.
So I've basically fallen for this game. The fact that I'm talking about this on the show, I'm talking about $109 million when no one's going to get $109 million. This is helping build their mystique.
Yeah, I assume they'll be sending a donation to KWMU.
I sure hope so. No, I'm joking. So Eric Banks, who's frequently a panelist on this show, he's a lawyer who's just sort of practicing day in, day out. He's there dealing with like the realities of what it's like to try to deal with some of these cases. And he says, this is just the beginning of the negotiation. You come in with $109 million, and that's sort of the opening to, okay, what are we going to settle this for? Do you think settlement negotiations are going on even as we speak, Jim?
You never know what stance parties are going to take, but I would hope so.
Is there a chance that they're even going to get, let's say $9 million is allowed under what the cap is? Will they get $9 million?
So if they think $9 million is the most that they can get, and then they're thinking, oh, there's the cost of going through all that appellate process, therein lies the negotiation, right? Somewhere between, no punitives and 9 million punitives, with Simon Law Firm kind of having the advantage on their side. That's where the negotiation is going to happen.
Well, this is an interesting one. I'd love to hear how it will end up shaking out. I feel like those are not the kind of issues where people then publicly trumpet what the settlement ultimately ends up being. This may be the last we hear of this lucky asphalt company.
There'll be a page 7 article buried somewhere.
Probably in Missouri Lawyers Weekly.
Yeah. Well, if they can't settle it in a timely fashion, we'll have an appeal.
There you go. We'll keep an eye out for that. So, a senior prank at Normandy High School saw students spread ketchup and mustard around the school. The police chief says that's criminal mischief. He says that police are going to look into misdemeanor charges. I think everybody who once was a senior in high school doing a prank, this fills your heart with some trepidation. Meanwhile, there's a dad in Wildwood who gave an angry interview to KSDK. He said the toilet papering of his house and the words that were written on his driveway were criminal. Now, in this case, the St. Louis County Police didn't even come out when the dad angrily called and said, "Come check out this criminal damage, the toilet paper hanging from my trees." They said there was no real damage to the man's property, so there was nothing they could do about it. So, Nicole, I want to ask you, you're a former prosecutor. What is the line between mischief and criminal mischief?
Well, so actually it's a much more boring line than that in the two cases that you just described, because the ketchup and mustard incident in the school was not just a ketchup and mustard incident. Apparently there was some property damage, which involved breaking metal detectors and things like that. So it is 100% prosecutable when someone causes property damage. The Wildwood thing maybe required a little bit of cleanup, but probably wasn't actual property damage. So that's probably a different issue. I think the interesting question is, should the kids be punished for this senior prank? even though they did, they probably did stuff that was technically chargeable, under criminal offenses. They probably did commit property damage. But that's where prosecutorial discretion comes in, and that's where prosecutors decide, look, do we want to give these kids a record because of this? Do we want to, what kind of punishment would we give them if we did charge this? And, those are the decisions that prosecutors are making every day.
So you mentioned this ketchup and mustard, that maybe wouldn't count as damage. But the fact that metal detectors were broken, obviously we can see that's real damage there. Having to clean up ketchup and mustard, that doesn't count as damage?
I mean, it depends how far it went, right? If it was thousands and thousands of dollars of cleanup, we'd be talking about something else, right? But we are talking about ketchup and mustard. I mean, not to make light of it, but I mean, so yes, cleanup could constitute, property damage if it's, significant. And I think even the property damage statute actually has a dollar amount in it for whether, it's what level of offense it's going to be. What I think when I practiced, it was $500. It may be significantly more now.
Inflation has maybe hit that part of the criminal code. Yeah. $500 worth of damage. Hard to think that toilet papering and chalk on the driveway would get you there. But Brenda, I think you maybe have a different take vis-a-vis this ketchup and mustarding of the school.
What I would say is, the definition would allow a wide range of behaviors actually to be subject, I think, to the statute because it's intentionally damage, defacing, or altering a person's property, right, without consent. What I would say is I'm going to date myself here, so your listeners may not know this reference. I would call it the Andy Griffith Rule. What would they do in Mayberry? You'd haul those kids in and you go, here's the mop, here's the disinfectant, go for it. And when they toilet paper your property, you haul them all in. The parents would make them all come in. They'd clean all the paper off the trees and get it all wrapped up. But that's not a legal standard.
And I was going to say, legally, can we even make people do that? I could just see the backlash. Parents being like, my kids shouldn't have to come and clean this up.
They absolutely should. And if they say that, that's when I say prosecute them.
and the way to make them do that is to say you do it or you're getting prosecuted.
There you go. You can kind of hold that above their head. Okay. So that would maybe be an effective way to use the prosecutor's office here.
Yes.
Okay. Coming straight from a former prosecutor. What about the idea of let's withhold graduation? That obviously has big consequences as well.
Right. So that's not really a legal issue, but the school, they officially, I think, have the authority to do that. So, watch out student pranksters in the future and but for the grace of whatever, go I.
Yeah. I think we're all lucky we grew up in an era when there were no surveillance cameras. Kids today have it a lot harder. So in our final 3 minutes or so today, 4 new judges have been named to the federal bench, and they are apparently desperately needed. They are also apparently very conservative. Former President Joe Biden's office apparently didn't nominate any judges in Missouri. And the Post-Dispatch says that's because Senator Josh Hawley refused to compromise on a, quote, package of nominees where each party could get some of what they wanted. So now we've got these 4 new judges that have come through, and the Post is saying this is sort of a triumph of Josh Hawley's gamesmanship here. Brenda, what do you think of this?
I don't know that that's the case. Senators do have what I guess it's called a blue slip where you can block judicial nominations. But typically, if you look at a state, and at the time that Biden was in office, we had 2 Republican senators. Typically, what the administration does is cooperate with the congressional delegation to nominate people and pick people that would be acceptable. And so there's a part of me that says maybe we should be asking the question of who was Cori Bush pushing for? Was she not being cooperative with the administration? We know that we had an acting U.S. attorney here in St. Louis for the entire time, and it's because she was pushing candidates that weren't even acceptable to the Biden administration. The vacancies occurred in early 3 of them occurred in early to mid-2023. And so I just think if we look across the country, we would see that states with Republican senators were getting judges. So I think you have to ask that question, whether she was part of the problem and not being part of the solution. And then having said that, I will add, I know one of these judges personally. It's Zach Bluestone. Guys, you don't have to worry. He is a man of integrity. He will be fair and honest. He's not going to bring his political philosophy to the bench. He's going to judge honestly and fairly.
I'm always so glad to get those kind of endorsements when somebody that I trust says, this is a good judge. I like to hear that. One of these other judges, this is a guy named Christian Stevens. He apparently wrote a law review paper. This is back in 1997, but he argued that harsh sentences for crack cocaine could be considered, quote, in fact, beneficial to black communities hit hardest by the crack epidemic, and then kind of made an argument along those lines. Jim, is that something that should be disqualifying?
I think that'll be something that the Senate panel looking at this may consider.
You think they'd go back to, hey, we're talking something that happened?
It's going to be a Republican Senate panel, but I'm sure some politician will make some noise about anything they can.
Nicole, in our final minute here, I guess just how much do these judges get scrutinized?
I mean, I think that is definitely something that could come up, right? You just saying that raised an eyebrow, right? So I think that is certainly something that is, justified to bring up and something worth, diving into.
So we now have 4 judges being named to this bench. Let's see if we end up with all 4. We'll follow up on that in future Legal Roundtables. Nicole Gorofsky of Jenkins & Kling, thank you for joining us.
Thank you for having me.
And Brenda Talent, CEO of the Show Me Institute, thank you.
Great to be here.
And Jim Wersch of the law firm Kazali Wersch, thank you.
Thank you.
This episode was produced by Sarah Fensky.
Our audio engineer is Aaron Dorr. This podcast was mixed and edited by Aaron.
Our executive producer is Alex Hoyer.
St. Louis on the Air is a production of St. Louis Public Radio. Understanding starts here.
Do you find yourself regularly listening to episodes of St. Louis on the Air? Suggest us to a friend you think might enjoy our conversations. And leave us a review and rating on Apple Podcasts on the App Store. It's the simplest way to help people discover our show. Thanks.
St. Louis Public Radio is a member-supported service of the University of Missouri St. Louis.